Now, my reason for this is this, that this is a rural community, as you know, and I do not, as the lawyer doesn't come to all the meetings, and I have not publicly, completely, I have not discussed this really with the supervisors at all, okay? And so they have not had my legal opinion. And going further, and I'm going to do a lot of talking, so you'll have to bear with me. Addressing one issue, there has been correspondence sent to the supervisors, and I've been copied. Certain people have made threats to sue the supervisors and the planning commission if they don't do certain things. And the reason I'm bringing that up, not intimidation or whatever, but to explain why we're talking publicly. I don't believe that even if, because there's threatened litigation, that my counseling my clients, which are the supervisors, your township, that even if that were technically legally proper to be done in executive session, I don't think, first of all, I'm going to explain in a minute, that there is any viable personal liability on them whatsoever, and I'll explain that in a minute, and that therefore my legal opinion on these issues should be given before all of you publicly, and that you should have input and able to comment about that, okay? So that's why we're going to do it this way. And so to give the basis of that, just a little background, it's not totally relevant, but the point is that, and I'm going to be getting this into this in great detail, okay? I am going to assert to you and to my clients that the Robinson Township case by the Supreme Court of Pennsylvania is indeed the most remarkable Pennsylvania Supreme Court decision ever. Not only in my lifetime, but ever, okay? And that's very important because it does finally enunciate certain constitutional rights that you people have as citizens of Pennsylvania. And I'm giving this as advice to my clients who are your elected representatives here. But there are problems in the enforcement of that, and the knee-jerk reaction for you as citizens is to say, okay, it's just like if somebody's violated the federal civil rights, and the analogy is that if they supervisors violated one of your federally constituted civil rights, you can sue them in federal court and get money damages and attorney's fees. That's not the case with Pennsylvania constitutional rights. First of all, there are only 3 states in the nation that have amended their constitutions to give its citizens environmental rights. Okay. Montana and Rhode Island and Pennsylvania. There is no federal law like that. And you know the makeup of our Congress, there never will be. You keep electing those same people to Congress, but that's another story. The point is, there is no concomitant Pennsylvania system, statutes or otherwise, that allows a citizen to sue to the extent that you can for federal rights deprivations. When Pennsylvania's Supreme Court started to get active the last 10 years, they found other rights that we have as Pennsylvanians greater than we have as citizens of the United States. They found that we have greater protection in our person and property against unreasonable searches and seizures. They found that we have greater freedom of speech in Pennsylvania than we have under the federal Constitution and decisions decided by the Supreme Court. But then when somebody sued based on that, and a judge in Philadelphia said, yes, we're going to award attorney's fees, etc., and I got all excited because I filed some of those lawsuits myself, then the appellate court said no. There's nothing put in. So that's the long version of telling my clients that they do not have any personal liability whatsoever for their role in what they decide as it affects your rights to your property, your environmental rights. You have the right to enforce your constitutional rights in court, injunctions, etc. Maybe reversing what the township might do. But they're not going to be personally liable, and you're not going to necessarily get attorney's fees unless the state legislature were to enact legislation, and that isn't going to be the case. But furthermore, under the sovereign immunity statutes in Pennsylvania, you can sue for money damages the public bodies, the municipalities like Wilmington Township, and the officials, only for certain specified things like when they're driving a motor vehicle, you fall on their property, etc. But these kinds of things, there are no money damages. So the threats that have been made about them personally, you don't worry about that. Okay. So there's no cause of action against you individually. Okay. Let's now. I want to give a little background because you had a nice question and answer period before we started. But I do want to, this background, and I'm going to get into the Supreme Court case in a minute. You really can't understand what's going on unless you know where the zoning ordinance is right now in Wilmington Township. Because what is proposed is to make an amendment to the ordinance and also do some things like the roads and some performance guarantees according to the ordinance. Now, as we sit here, the most recent enactment of Wilmington Township in zoning was Ordinance 105 of 1987. And in that, it dealt with oil and gas extraction. Now, of course, in 1987, frankly, I never even heard of Marcellus or Utica shale, and I never heard of fracking, and I doubt that the supervisors then did. There, some savants in geology may have known about it, but we didn't. But so, needless to say, there's no question that when the ordinance was enacted and oil and gas drilling was located in the ordinance, it was, as the expression goes, your grandfather's gas well, certainly. But anyway, as it sits right now, if we don't change the ordinance, there is no distinction between conventional or unconventional gas drilling, okay? Whatever you want to call it, Marcellus shale, or the extraction of gas and oil through fracking, okay? There is no distinction. If you intimidate the supervisor so much that they do nothing, like you did the last meeting, then you are going to have it as it is, and Marcellus activity will come in like any traditional, non-conventional gas drilling. Okay, so that's it. Now, right now, let's take these zoning classifications as we go. R1 residential, there is no gas or mineral extraction under the zoning rules. We're going to talk about Act 13 of 2000, whatever it is, 12, in a minute. The R2 residential, which allows multiple family dwellings, etc., none. Okay. Commercial allows oil and gas drillings as special exception. In the industrial zone, allows oil and gas drilling as special exception, and oil and fuel distribution and storage as conditional use. The A, agriculture, allows oil and gas drilling as special exception. Now, what special exception means is that there are in the ordinance, in 800.21 and sub-paragraphs under that, it's on page 29 of the ordinance, certain performance guarantees, setbacks, which at this point are 100 feet from any adjacent property line or public road, 200 feet from an existing dwelling, school, hospital, or residential use or water source. And then some other things. And then one of them also talks about that the township can, the zoning hearing board may require the imposition of a performance guarantee. That is another issue that is on the table for the supervisors tonight, because we really don't have any details about the performance guarantee, and we'll talk about that. Okay, and that they may reduce that guarantee as the project goes on, and then when the well is plugged, then it can bring it down to 0. Now, so that's where the current ordinance is. Now, what is on the table for tonight are 3 activities. One is to increase the weight limit to 10 tons on, I forget how many roads, 16 roads, I think it is, 16 township roads that don't have any weight limitations. And without that, you can imagine the damage. And if Marcellus trucks go over it that are greater than that, they have to come to the township and post bonds for the damage and repair the damage. So that is one of the ordinances that's on the table. The second is a resolution that imposes conditions. And for that, when we discuss, maybe Jay will get into that, the details, but that will be read to you before the supervisors vote. That basically is requiring security. And there are state rules, regulations about the kind of security. It can be a certificate of deposit, and the security will be posted by the gas company for damages that they might do. And we don't have any of that imposed now. So without, and that can be done, our ordinance provides that the supervisors can do that by resolution, which means that they don't have to advertise it and that they can change it at any meeting. So if you guys say to everybody, planning commission, go back to the drawing board, we want it fine, we want it better, we want it bigger, they can. But right now there's nothing. And it's very difficult reading right now. When I look at the state rules, it's either the state requires a bond for gas wells. It's either $1,600 or $2,500 max. You can imagine if something goes wrong with a well, how far $2,500?
Yeah.
So I think that's another thing. And maybe you're going to say what we're talking about is inadequate, but again, that can be done. It can be refined. Okay. And then the third one is amendments to the zoning ordinance to increase, to actually for the first time make 2 classes, to make a distinction between the conventional, your grandfather's gas well, as the expression goes, and you know we're all familiar with that. When I go hunting up in Forest County, you know you go in the woods and you know there's that gas thing going up and down, and it's not even scary to get the deer, you know. So you know that's one kind. And then, as you know, you've seen it, just drive down 79, the thing with all the lights. It looks like a thing from outer space. You know that's a different kind of gas well. So that we do have a distinction with greater setbacks. And then we put in some noise, hopefully some noise issues. There might be an issue whether it's too restrictive, that in fact they can't do it. We'll deal with that. But right now we have no noise limitation. So you know it's modest, and I'm going to get into that. It's too modest, but we'll talk about that. But again, it's now, and I'm going to give the supervisors my advice and what my recommendation is, but to do nothing with the fact that there is an activity. Let's see, I have it here. We did receive a notice that a permit was applied for, and I wrote the state and said we've got zoning restrictions, because right now they can't do it. Just to summarize, they can't do it and say, I think this one is in an ag zone, that they have to have approval by the zoning hearing board, and there are certain limitations. But there has not been a formal application made to the township. Now, let's go further. When a municipality advertises a proposed ordinance, if once it's publicly advertised, and this particular ordinance dealing with the zoning amendment was put in the paper about May 8th of this year. Okay. Once that's put in, then a developer or a property owner can't just run in and say, all right, now we're going to get our application in before the new ordinance comes in. There's this thing called the pending ordinance law that if we then ultimately enact it, then the applicant is stuck with the new zoning ordinance. So that's another reason why, because we do have the shot over the bow, so to speak, that there is going to be an application, that we wanted to hurry up and get something down so that we at least have some kind of ordinance amendment. And again, I'm going to recommend that we go back to the drawing board and do even more, but something, a little bit we have is better than nothing. Okay, that's that point. Now, I now want to talk about the Robinson Township case. The background is really remarkable. In, what year was that? 12, I think, I'm not sure, 10. The legislature passed what is called Act 13. Act 13 said it was special for the gas and oil extraction, that that gas drilling activity and storage and compressors and all that comes with it must be allowed in any zoning district in the Commonwealth of Pennsylvania, anywhere. And that the townships, municipalities, cities were given X number of months or whatever to amend their ordinances to so provide. Now, we didn't do that in Wilmington Township, so we just sat on our hands. And it provided for waivers. The PUC and the DEP could give waivers of what existing setbacks there are to the gas companies, and that only the gas companies could appeal the decisions. The citizens and even the local municipalities couldn't. There was a lawsuit filed. Robinson Township, some other townships, citizens, a lot of plaintiffs sued. The case ultimately went to the Pennsylvania Supreme Court. Now, the decision is enormous. This is the decision. And and it was decided September, well, according to September 28 or 11, but it took a while to perk around. No, that's not wrong. Just one. Yeah, right. Okay, we get to that right one. Yes, it was decided December 19th, 2013. Okay, so I attended a PSATS, that is the Pennsylvania Association of Township Supervisors seminar on this in like February. And I got lots of information, literature discussing it and describing it. And until I read the decision, I never really got the full impact. And that's why I want to discuss with my clients and you some of the details. And I hope I don't put you all to sleep. But you have to hear the details of this decision because it puts it in a proper context. But I'm also going to discuss some of the dilemmas that the supervisors have. Okay. As was said here before we had the meeting, the Supreme Court has characterized the Marcellus activity as an industrial use. Okay. I guess one piece of the puzzle I haven't told you about was, and it comes in the decision, that way back in about 71 or 72, we voters in Pennsylvania voted for an amendment to our Constitution. Okay, and that amendment declared what already existed, because that's one of the things they say about constitutional amendments. They merely declare what we always had, but we didn't really have.
Act 1, Section 27.
Yes, Section 27 of Article 1. And it basically says that the people of Pennsylvania have the constitutional right to a clean environment. Okay. That provision had basically been ignored, and people thought it was just window dressing. But that is the provision upon which the Supreme Court has made its decision. The lawsuit And the context of the lawsuit was basically against the state, because the state defended Act 13 and argued many defenses. But the important thing is that it requires, the court held that the Environmental Rights Amendment requires the General Assembly to exercise its police powers to foster what it calls sustainable development in a manner that respects the reserved rights of the people to a clean, healthy, and aesthetically pleasing environment. Now, the intent of the preamble to Act 13, which was passed by the General Assembly along absolute party lines, signed by the governor, said that the function of the statute was to encourage as much as possible the development of the Marcellus Utica Shale, and said nothing about environmental protection. Now, the duty that the Supreme Court has found on the General Assembly also applies to township supervisors. And if the supervisors believe, however, that they want to continue to allow the unconventional drilling in more than industrial zones, if you gentlemen do not want to amend the ordinance to, and that's not on the table right now anyway. Down the road, if you choose not to restrict the Marcellus activity to only the industrial, but continue to allow it in the ag and the commercial, you do still have a duty to impose sufficient controls on the drilling activity to respect the rights of the neighborhood and the surrounding vicinity. And those rights are a clean, healthy, and aesthetically pleasing environment. That's not me talking, that's the Supreme Court of the state. And that duty, I think, obligates you to re-examine the extent of what controls you have in the existing ordinance and what you're going to enact tonight, okay? We have, it's a totally different playing field now. Before, the attitude of everybody in Harrisburg, including the courts, was that the state was preempting the regulation of oil and gas, and that we had very narrow rights, that yes, we could say they go here or they go there, but we couldn't put controls on them. I believe that until the Pennsylvania legislature enacts sufficient statewide controls on this activity that satisfy the state Supreme Court, that we local people have the right to put on controls to at least make an attempt to protect the environment. And but right now, the court is absolutely crystal clear that the state hasn't done its job. And the opinion stresses that this issue requires the responsiveness of the local concerns, that they absolutely were outraged by the one-size-fits-all solution, one-size-fits-all pronouncement in Harrisburg, that they must consider the concerns of the residents, business owners, and the locally elected representatives. And that imposes a duty on the township officials to consider such concerns in addressing the future of unconventional gas wells in Wilmington Township. Now, it's unfortunate that they didn't strike down the whole Act 13 altogether, which I wish they had. They left a few things in the law, which make no sense as far as I'm concerned. And one of them is, whatever we do that affects oil and gas drilling, we still must submit it to the PUC for a 120-day comment period. There is some uncertainty, some aspects the PUC can reverse us, and some aspects it's only advisory, so that that all they can do is tell us and we can say we don't have to listen to them. So that where I'm going at the end is that we consider additional controls. We're going to then have to give them another 120 days. We did send notice to the PUC, but their time hasn't run out. But we'll have to do it again for whatever new stuff we do. Okay, now, but the Supreme Court used this language that the political subdivision has a substantial direct and immediate interest in protecting the environment and quality of life within its borders, which interest confers upon the political subdivision standing in legal action to enforce environmental standards. Okay. And then it says, and again, this is a quote, "The protection of environmental and aesthetic interests is an essential aspect of Pennsylvania's quality of life and a key part of local government's role." Now, I might say, I'm going to give you a disclaimer here. I personally signed Marcellus, a Hill Court gas lease, okay? So I'm not a tree hugger, but I'm giving you the law, not my opinion. This is the law of Pennsylvania. Okay. And that the supervisors have a responsibility to protect the quality of life of its citizens, and the court describes that as a constitutional duty. And like I said, the part of the ire, the outrage of the Supreme Court was that the legislature forced all this activity, not just drilling, but even compressors and storage and the whole bit, on all neighborhoods in the state. Okay, not including residential. And unlimited hours of operation, and it could take place anywhere. Okay. And they went on to say that Article 27 of the Constitution also says that the government is a trustee for the rights of not only the existing citizens, but future generations. And that trusteeship is not just in the General Assembly, but it's also in your local representatives.
It's public land.
Well, here's the point. That second portion of Article 27 specifically does refer to the public environment. And that would be, of course, state parks, rivers, lakes. But the court went on to say that public environment also includes the air and the water and the animals and the fish. And that even if that air, that water, those animals, and those fish are on what are called private lands. So this trusteeship is more than merely the state game lands. Okay. And that the duty is to protect that from harm and damage, and as it says, to ensure the maintenance and perpetuation of an environment of quality for the benefit of future generations. Yeah, that's the Supreme Court talking, it's not me. Okay. Now, it's interesting that they say on the first section that it is the local government doesn't necessarily have to take affirmative measures to promote clean air, pure water, and the preservation of the environmental values of the environment. But they do have a duty to refrain from unduly infringing and violating those rights. And that's what outraged the Supreme Court, because obviously Act 13 took away those rights and gave basically what is a blank check to the gas industry.
What do you need?
Okay, the current proposal right now that the supervisors have in front of you does leave the location of gas wells. And, but if the, okay, but my point is that they must act to restrict Marcellus activity. Well, in other words, the question is, the supervisors are being asked by some of you to restrict the drilling activity only to the industrial zones. Okay. And the issue is that can the supervisors permit the oil and gas drilling in agriculture and commercial? Can that be done and still not deprive the clean environment rights of the neighborhood? That, of course, no, we don't know for sure. And the mission will be for the planning commission and the supervisors to see if that can be done. Now, if it cannot be done, and if the supervisors were to decide, and that's theirs, it's not my decision, if they were to decide that it can't be done, and that the only place this activity should take place is the industrial zone, we're gonna get into that, the extent of that, and the lack of extent of that. And if the township is sued, I'm not recommending that they necessarily do that, but if they do, I'll defend it, because I think it's a legitimate, defensible position. Because the environmental rights of the neighbors have been clearly expressed by the Supreme Court as a constitutional right, and that's it's important. But there is no doubt, in my opinion, as your solicitor, that the Marcellus shale gas activity, as currently allowed in current ordinance, does have a clear and present danger in harming the environmental rights of the neighbors and perhaps the entire township. And so my advice to you is, so I strongly advise that you enact what is on the table now for controls, and we all go back to the drawing board and see what more we can do, okay? And the duty is to ameliorate as much as possible the harms that might result from without controls. Now, since we devised these things that are on the table, I've been in contact with some other municipalities, and one of them is Neshannock Township. And you've probably read in the paper, and they haven't even read the decision yet, but they amended their ordinance just last year to include some additional controls. And I provided that to Jay, and it may not even be enough, but I think we ought to at least do what they've done, if not more, that there are additional controls we can do, even if we allow it to continue in base. Now, our commercial zone area is very small, so that's probably, and there's probably not enough of it to take any well, so we're really talking about the agriculture. But there's no question that it is going to be an intrusion and we have to deal with that. Okay. To give you more flavor, another quote, the benchmark for decision is the express purpose of the Environmental Rights Amendment to be a bulwark against actual or likely degradation of, among other things, our air and water quality. And then the Supreme Court goes on to say that in order to impose some kind of control, it doesn't have to be against something that has already been proven to be harmful to the environment. In other words, you don't have to wait for this awful thing to happen to anticipate. In other words, they're calling the signals. They're saying that when they review these restrictions, that we don't have to prove that we don't have to prove it. They have to. In other words, another thing that outraged the Supreme Court was that if the DEP or the PUC imposed restrictions on Marcellus or Utica activity, which they really didn't think they would, because as you know, they're in their pocket, but that's another story. But if they did, the only appeal the township could appeal, the citizens could appeal, only the gas companies. And the statute enacted by the legislature said that the controls had to prove that they were absolutely necessary. In other words, unless you could prove that there was this harm, you had to prove that otherwise the burden of proof was on the entity imposing the limitation, not on the gas company to prove that they could do it safely. The Supreme Court says they called it topsy-turvy. So the point is that if we do impose things, and we are taking it, we don't necessarily have to prove the science, and because that's the Supreme Court talking. Okay.
So the burden of proof is where?
It's going to be on the gas companies to show that whatever we impose is not reasonable. In other words, it says that we're allowed to provide anticipatory and preventative protection against unreasonable degradation of natural resources. Okay. And so the point is, put it in the context of, say, me, okay? My entitlement to royalties under my Hill Court lease, okay, my property right is protected under the Constitution. We'll get into that in a minute. But it doesn't take precedence over my next door neighbor's rights to their environmental rights. So there is, and the Supreme Court then talks about this. It calls it a dilemma, that there will be competing constitutional rights. Now, as a lawyer, this is something I find my clients have a very difficult time understanding. They like the law to be black and white and very simplistic. Though, particularly with constitutional rights, it's not black and white. There are always competing problems, competing interests. The Supreme Court in this decision gives an example. One example is free speech. Okay, we have a right to free speech, but we also have laws about defamation. So I can't lie and defame someone on the basis of free speech. So there is a conflict. Okay, so that is true with certain property rights. Now, the conflict did not exist, however, in the attack on Act 13, because Act 13 was not like what we have. Act 13 decimated all local zoning. Now, the problem is, for Wilmington Township, that what we have here is that we have probably, as we sit here, probably over 80% of the land in the township has already been signed up for gas leasing, okay? And there are people who have an expectation that they're going to get a future income stream. That's already been done, okay? That is a property right which is protected by a different provision of Article 1 of the Pennsylvania Constitution. So the problem is, it was easy for the Supreme Court to throw out Act 13 because it was all one-sided. But here, we have existing ones. So here comes the problem. Certainly, the supervisors have discretion where to locate uses, as long as it's not outrageous or exclusionary. And we're going to get into exclusionary in a minute. If we were, unfortunately, time has passed. If nobody had any leases, nobody had made any commitments and signed any contracts, then there would be no vested property rights. It would all be hypothetical. But it's not hypothetical. Here's the problem. The problem is that the Supreme Court also talked very much about one of the things that was outrageous about Act 13 was that it eliminated zoning protection as applied to gas and oil drilling. So that people who bought their homes, particularly they were focusing on residential neighborhoods, people who bought their homes thinking that they were going to have a nice, quiet residential neighborhood, can now have all this stuff thrown on them. And they stressed the expectations of existing zoning. Now, that's different from the Wilmington Township case, because here we have many of your neighbors, and maybe some of you, have made commitments and have signed contracts and have rights. And that, therefore, that has to be looked at, because they made decisions too, based on the existing zoning. And the Supreme Court says that's an important consideration for the local government people and the state and the courts. So the problem is that we've made an assessment, and here's where it stands. The total acreage of Wilmington Township is 12,750 acres. The total industrial acreage in Wilmington Township is 101.4. That comes to 0.7% of the township. And when you consider that much of that is the dairy farmers, Along Honeybee Lane, most of that's already taken. Westminster College, they haven't even signed their gas rights and their power plant. And then there's industrial uses on what's called Western Reserve on the eastern side of the borough. And the problem is, that's what I'm telling my clients and all of you, is that if you guys were to amend your zoning ordinance to restrict the gas drilling to the industrial, now you've already restricted all the other gas activity, the compressors, the storage. That can only be industrial. That's already. But the drilling itself, if you do that, you will be at 0.7%. Now, case law in Pennsylvania is that up to 1.16% was declared to be exclusionary and not a fair share. So that is an issue on the other side. And that's why your decision is not easy. Because as a practical matter, if you restrict the drilling to the industrial zone, then you may have basically, we call that de facto, you may have in de facto zoned it out of the township completely. So, and again, that's to be studied. You don't have to decide that tonight. That's not on the table. But that is a concern. Okay, getting close to the end, and then I'll shut up here in a minute. I think that pretty well brings to the conclusion that, like I said, you are in the Robinson Township case required to consider what they refer to as the settled expectations of the residents of the township. But again, the environmental impact is something that you must seriously take into consideration. It's not enough to merely say there is a ton of money coming down the pipe. And we want that ton of money, and we're going to do everything we can to facilitate it. And I want to read you, because I think this is important. You have to hear the flavor of the Supreme Court in what it's saying here. Because what they're saying, for instance, here's a quote. That Pennsylvania deliberately chose a course different from virtually all of its sister states speaks to the Commonwealth's experience. And they're talking about the constitutional amendment, not Act 13. They're talking about government quarter. They're talking about pre-government quarter. Okay. Of having the benefit of vast natural resources whose virtually unrestrained exploitation, while initially a boon to investors, industry, and citizens, led to destructive and lasting consequences, not only for the environment, but also for the citizens' quality of life. Later generations paid and continue to pay a tribute to early, uncontrolled, and unsustainable development financially, in health and quality of life consequences, and with the relegation to history books of valuable natural and aesthetic aspects of our environmental inheritance. The drafters and the citizens of the Commonwealth who ratified the Environmental Rights Amendment, aware of this history, articulated the people's rights and the government's duties to the people in broad and flexible terms that would permit not only reactive but also anticipatory protection of the environment for the benefit of current and future generations. Moreover, public trustee duties were delegated concomitantly to all branches and levels of government in recognition that the quality of the environment is a task with local and statewide implications, and to ensure that all government neither infringed upon the people's rights nor failed to act for the benefit of the people in this area crucial to the well-being of all Pennsylvania. And they even go on to give the